Hi, my name is Genesis Suggs. Today I'm speaking with former immigration judge Kristi Nelson.
Hi, thank you for having me here today. My name is Kristi Nelson. I'm a former immigration judge in the Chicago Immigration Court. I graduated from DePaul Law in 1995. And when I heard that there were immigration judge positions opening up, it interested me to serve in that role just because of pro bono immigration work I had done. In addition to representing individuals in immigration court proceedings through National Immigrant Justice Center, I also did some other volunteer work. During the Trump's first administration, I traveled to border town in Texas where I represented mothers and children that were being detained in a detention center, helping to prepare them for their credible fear interviews. And, I also found that to be very rewarding work. So that's kind of what led me to the immigration judge position in the Chicago Immigration Court. So an immigration judge is hearing cases that are brought by the government. They're called removal proceedings. Most people, when you hear the word removal, it's otherwise known as deportation. I think most people are more familiar with the term deportation. However, in immigration court, we call it removal. The Department of Homeland Security is the party that files the case, and the Department of Homeland Security, on behalf of the government, is seeking to have these individuals removed from the United States. There's really two main questions that an immigration judge has to decide. Number one, is the respondent subject to removal from the United States as alleged by the government in the document, which is called a notice to appear? And even if you find that the individual is subject to removal from the United States, they have various forms of relief that they can seek to avoid removal, such as asylum. So even if a judge finds, yes, you're subject to removal, the next question we have to decide is there any form of relief available to the respondent? One thing that differs in immigration court, and I wasn't really aware of it until I was in the role, is that under the statutory federal law, an immigration judge has an obligation to ask the respondent, or develop the record is the terminology used, to see if they're eligible for relief. So even if a respondent doesn't have an attorney and they're pro se in your courtroom, it's part of the immigration judge's job to develop the record to determine whether or not they might be eligible for some sort of relief that would allow them to remain in the United States. I think that's different than any court I've practiced in. I'm not aware of other judges having a duty to develop the record, because in that way you're almost, not that you're acting as an attorney for a party, but it's a little bit different than I think other judges have in, let's say, federal court or even in a state court proceeding. I can't really weigh in on what it's like to be a judge since April 2025, but what I have noticed is that the administration now is expanding the use of what's called expedited removal, which means that the respondents are not put in immigration court proceedings. It's a much more streamlined process and faster process to deport people from the United States. And my concern about that expanded use of expedited removal is that when a respondent is in immigration court, they have due process rights, that they have an opportunity to be heard. They have opportunities to, present issues and facts that would, block them from being removed. But when they're not afforded the opportunity to appear in front of an immigration judge in immigration court, they don't have those same protections. So one of my primary concerns with what's happening right now is the expanded use of both detention and expedited removal. Well, when I was on the bench, I had 10,500 cases assigned to my docket, which is, very high number of cases. When a judge leaves, those 10,500 cases would have to be reassigned to my colleagues on the bench, which, I felt badly about that. But even since I've left, several judges in Chicago have been terminated without being given any reason whatsoever for their termination. So it's just vastly increases the backlog that already exists. We were already understaffed. The number of cases assigned to each judge was enormous. And now with the terminations and others leaving voluntarily just because of the circumstances, the backlog is, even greater, and it just results in, increased time for cases to be resolved. It's not uncommon in immigration court for cases to take 5-10 years for resolution. I'm sure with all of these terminations, it's even worse now. Well, I do think that there is a very high demand for attorneys that are willing to represent respondents in immigration court. There's another difference, going back to a question you asked me earlier, is differences between immigration court and other courts. There's a much higher percentage of pro se respondents that appear in immigration court, I would say, than other courts. And it's not surprising. A lot of the respondents that are appearing in court don't have the financial means to hire attorneys to represent them, which is why nonprofits such as NIJC are so important. Attorneys that are willing to represent respondents pro bono, there's a huge demand for that in the immigration courts. Most of the judges that I worked with, or I guess I would say all of the judges I worked with in Chicago, are very, diligent. They care a lot about due process and the rule of law. And so I think that, respondents that appear in immigration court, from my experience, at least in Chicago, are going to be given a fair opportunity to present their case. But if they don't have legal representation, it makes it very difficult because immigration law is so complex. So I would say that, attorneys and advocates just stepping forward and trying to represent the respondents in immigration court, or if you're not going to be representing them in court, volunteering in other capacities just to try to explain their rights, helping them fill out the paperwork, translating for them if you speak another language. All of those services are in high demand. I am just very concerned about the termination of immigration judges. Reason, I think that, in my mind, there are concerns that these terminations are politically based. Our job is not politics. Our job as a judge is take the facts that are presented to us and apply the law to those facts. And regardless of which party you align with, that should be the job. My concern is that this administration is just trying to terminate and fire federal employees, including immigration judges, that they don't mind, and it doesn't seem there's no rhyme or there's no basis to it other than that, because these are high-performing judges. They were hearing a lot of cases, and there's just no rationale for it. And so I just, I steadfastly stand beside my former colleagues in the Chicago Immigration Court, those who were fired, those who resigned, those who are still there.